Again, you'll get each of you will have 2 minutes to answer, and you'll each have like a minute of rebuttal. So we're going to start with Dawn. And this is a combination of a few questions that have been submitted. Please describe what particular qualifications you believe that you have that you believe make you uniquely suited to the job of district attorney. And a community member has asked both of you to please include information about your college and law school educations and how the curricula of those particular the educational degrees prepared you for the responsibilities of the district attorney. So we'll start with Dawn.
First of all, my qualifications, okay, I expressed a few minutes ago. I went to high school here in Lakeport, graduated in 1970. Then I spent 2 years in Santa Rosa at the junior college there. I was on the campus police, studying administration of justice. Then I went to San Jose State University, actually practiced there, learned there for about a year, and then I was hired full-time with the sheriff's office here. And during that time with the sheriff's office, I learned a lot. And not just from opening books, but I learned a lot from the streets. You got to learn to talk to people, to investigate crimes, to sympathize and feel for the people. You know, during my time with the Narcotic Task Force, which is a 2-year period, I had gone to law school and saw a whole different side, even narcotics, working narcotics, that regardless of how bad a people can be, they're still people, and they have to be treated with respect. After graduating from law school, I had to make a decision, law or law enforcement, and I decided law. For 20 years, I did a lot of civil litigation, family law, and some criminal law. Doing the criminal law as a defense attorney, again, taught me a lot. It showed me a whole different side, that not everybody is bad, everybody, usually your criminals are good people doing bad things, at least the vast majority of them. I have been a district attorney for the last 3.5 years, learned a lot, and as far as my qualifications, that's what I've been doing, it's been working. And just lastly, the issue about law school and what you learn. One thing I learned about law school is they taught you very early on, law school is not going to teach you to be a lawyer, it's going to only teach you how to think like one. I'm sorry.
Thank you. Andre.
I graduated in 1983 from a college called St. Olaf College in Northfield, Minnesota. Yes, it's a real-life place and not part of a television sitcom. I was a double major in economics and German. I was awarded a Fulbright scholarship to spend a year studying at the University of Hamburg in Germany, studying the West German Environmental Party, the Green Party. After I finished my Fulbright year, I was a graduate student in the Department of Political Economics at Johns Hopkins University in Baltimore, Maryland, where I was on a PhD track to become a college professor in economics. I successfully passed all of my PhD qualifying exams, spent a year grinding away on a thesis, and decided that it was time to move west to enjoy the sunny climes of California closer to family. I started law school at UC Hastings College of the Law in 1990, graduated in 1993, intending to become a criminal defense lawyer and trial lawyer. I took the bar exam in 1994, and then for personal reasons having to do with a relationship, decided to emigrate to Germany and start a career there. For the same set of reasons, I came back to the United States in 1999, and because I hadn't practiced criminal law in a while, I decided to continue on with commercial law, and I've spent the past 19 or so years working. 7 of those have been with an attorney you might have heard of here in town by the name of Mike Ewing. Okay, that's the warning sign, correct?
Yes.
I know that people are critical of the fact that I haven't practiced criminal law full-time for 20 years. I don't think that has any bearing on one's qualifications to apply sound judgment and intelligence to difficult situations. The law is always changing. but the tools one needs to have in their tool set to do a good job remain the same. Honesty, integrity, intelligence, and courage are just four.
I gave you an extra 5 because Don had some extra.
Commitment to justice works as well.
Don, did you want to offer 1 minute of follow-up? Did you want to offer 1 minute of follow-up rebuttal to anything he said?
Yes, if I may, please. No, actually, no, I will pass. It was in his opening statement.
Okay. Andre? 1 minute of any follow-up that you wanted? Did you want to finish any thought at the same time?
I think one needs to distinguish between the job of the district attorney, which is an executive position where policies are determined and priorities are determined, and a finite set of resources are allocated over a variety of different priorities. I'm not running to be elected a practicing line attorney. We have plenty of capable, competent deputy DAs in the office, many of whom were hired by Mr. Anderson's predecessor in office. I think there's ample talent in the department. Where I think the department could be improved most is at the very top. Lake County has serious problems with crime and criminality that are going to persist for decades to come. It is of incredible importance that we have a wise and sensible district attorney to move Lake County forward into the 21st century, kicking and screaming if necessary.
Thank you. Question number 2, and we start with Andre. What should be the #1 prosecution priority for the Lake County District Attorney's Office?
Public safety, including the safety of our first responders and our enforcement personnel. The overwhelming majority of crime today is committed by repeat offenders who are engaged in nonviolent criminal conduct. We have a serious problem with violent crime and criminality in Lake County. We have more than our fair share of murders and home invasion robberies, and we need to emphasize the prosecution and punishment of serious and violent crime as our #1 priority.
Thank you. Don?
My philosophy is summed up best by Justice Sutherland of the U.S. Supreme Court in 5 words. He said in a famous decision that a prosecutor's duty is to prosecute vigorously but seek justice. What that means, you can prosecute anybody for anything because the district attorney's office has a tremendous amount of discretion and a tremendous amount of power, and sometimes maybe even too much power. But you have to seek justice in whatever you do. Well, of course, it's pretty common, and it doesn't take a brain scientist to know that the most serious cases you want to prosecute to the fullest extent of the law. But there's other cases which you don't want to prosecute to the fullest extent of the law. You want to use the spirit of the law, not necessarily the letter of the law. So maybe my first priority would be to follow that philosophy, that we will prosecute anybody, anytime, if it's warranted. And that's fine.
Thank you. Andre, 1 minute of follow-up or rebuttal.
I agree that one should prosecute vigorously but seek justice. I agree that one should follow the letter of the law. I disagree with Mr. Anderson when it comes to the spirit of the law.
Well, if we're going to argue...
Thank you. Andre, are you finished? Okay. Don, 1 minute of follow-up or rebuttal.
Okay. You can't, and Andre, I don't want to argue with you, but you cannot follow the letter of the law every single time. You have to know the spirit of the law. And if I give you an example of that, if a person is up in the middle of the wilderness in a snowstorm, and he kills a deer out of season so he can eat, he can feed his family, are you going to prosecute him for poaching, or are you going to do the spirit of the law and allow that man to break?
Thank you.
Is that a legitimate question? Do I have to answer that question?
Since we've already had the 2 rebuttals, why don't you make a note and you can address it in your closings.
Very good.
Question 3. This is kind of a 2-parter. Since the last election for district attorney, California has implemented AB 109, which instituted correctional realignment and placed greater pressure on counties like Lake when it comes to dealing with offenders. Discuss what you think the overall impact of correctional alignment has been on Lake County. And if you're elected district attorney for the next 4 years, what specific actions would you take to address the changes to the local criminal justice system resulting from correctional realignment?
First of all, the impact is just starting. For the roughly 3 years AB 109 has been in place, we've had a lot of criminals back into the community that should be in prison. You always heard when it first came out, there are the 3 nons: non-violent, non-sexual, and non-serious felonies. But what's turned out to be is you have a lot of very serious, very violent people that are now out in our community when they should be in the state prison system. They are housed, these very violent, very serious felons are housed in the county jail. So not only is that these people staying local, but they're influencing the moderate criminals or the medium criminals, how do you say that? The low weights, the not very serious criminals, but they're being housed with very violent people. And when they get out, they're going to be violent. They're going to be serious criminals within themselves. The problem is, first of all, right now we're kind of keeping up. We're about at our maximum level. In the near future, it's going to be worse. And it's going to continue to be worse as long as AB 109 is in place. What we've done is, I've taken a position, we're going to still prosecute and try to get the highest sentence for these violent felons, whether or not they're going to be housed in a county jail or whether they go to state prison. I have implemented other programs, like the diversion program and the alternative community service program, in order to get the minor, non-violent, misdemeanor people out of jail so it can make room for the people that are going to be in jail that need to be in jail.
Thank you. Andre?
I think AB 109 has placed a lot of additional burdens on small rural counties like ours. One read recently that our jail is fuller than it should be. I give credit to Sheriff Rivero for having secured additional resources to expand the Hill Road facility, and I encourage him to do it again to the extent that he can. We're going to have to be smarter about who we reserve our jail beds for, and we're going to have to be smarter about who we initiate prosecutions on. I don't think housing marijuana clippers is a wise investment of valuable space in the Hill Road jail when we have other candidates who are better suited for incarceration. In terms of programs to reduce the inflow, certainly diversion is an excellent idea. It's not a new idea, it's been around a while. We also need to intervene with younger people who are at risk of offending. I'm a member of Lakeport Kiwanis. We do a lot of community work for the benefit of young people in Lake County. Those programs, social welfare programs and social benefit programs, need to be emphasized. I'd like to encourage my deputy DAs to all get involved in doing community work in their free time as well. Given a finite number of jail beds and a growing number of offenders, we simply have to be smarter about who we prosecute and who we use discretion to not prosecute.
Thank you. Don, 1 minute of rebuttal or follow-up.
I do very much agree with Andre. We have to use our discretion on who we prosecute. And that's why, and exactly why, it takes someone with experience in criminal law and criminal procedure to make those decisions. We have in our office some very good, extremely talented deputy DAs. But I will not put those decisions on them. Whatever case comes through my office, I am responsible for it. Each and every single one. Whether it's just a traffic ticket or it's a murder case. The DA is responsible for it, and the buck stops with the DA's office, with the district attorney himself. And that's why you need the experience, you need the qualifications, in not only criminal law and procedure, but in life experiences. And that's what I've been doing for the last 3.5 years. And I think doing very well. BJ.
Andre, 1 minute of follow-up or rebuttal.
The second priority on my priority list is public integrity. I think we need to deal with the perception that Lake County government cannot function well to serve Lake County's voters. In order to reduce the flow of inmates into our criminal justice system, there are other agencies in the county that can be encouraged and facilitated in a responsible way to help reduce the inflow of criminal offenders. More importantly, I think we need to do a thorough house cleaning within the district attorney's department to ensure that politically motivated cases are not consuming the time or energy or resources of either the district attorney or his Bureau of Investigators.
Thank you. Next question, we start with Andre. Marijuana-related cases continue to be a large part of the local criminal caseload. What's your philosophy of how marijuana cases should be prosecuted? Do you think there currently is too much prosecution of marijuana cases or not enough?
I think the issue of marijuana is very complex, and as everyone knows in Lake County, the laws are changing and the problems continue to grow. There are many negative side effects and consequences of unrestricted, unlimited, and unregulated marijuana cultivation. There are plenty of folks who are engaged in criminal conduct who are using medical marijuana as a shield to conceal other criminal activities. I think a smart marijuana policy is based on the following. You have to recognize that we have a finite amount of resources to devote to prosecuting marijuana. We also have to recognize that California law under Prop 215 provides a safe harbor for legitimate, genuine medical marijuana patients. The problem is, in my opinion, that there are many folks who don't qualify for the safe harbor who are utilizing the safe harbor as a pretense to engage in other forms of criminal conduct. Cartel grows, trespass grows, grows involving weapons, grows involving human trafficking, grows involving other drugs. There's no such thing as medical methamphetamine. And the methamphetamine-driven crime in Lake County is another very serious problem. I don't think you can answer the question, should we prosecute more marijuana cases or fewer marijuana cases? I think the answer is we need to acknowledge and protect the rights of genuine law-abiding medical marijuana patients and growers, and we need to prosecute people who abuse that safe harbor for other criminal and illegitimate purposes.
Thank you. Don, 2 minutes.
You know, it's not the job of the district attorney's office to make the laws. Now, whether I agree with the marijuana laws or disagree with them, it really has no relevancy. What laws we do have on the books are very difficult to enforce. One reason because of the way they're written. The other reason is because the Attorney General has not come down with strict guidelines to tell us what to do, and the Attorney General hasn't given us the opinion. So it's left up to the individual prosecutors in each county to interpret the laws themselves the best they can. So whatever laws are on the books will be the ones I'm enforcing. Like it or not, that's what we have to do. I can't select what laws I'm going to enforce or what I cannot enforce. The emphasis I do have, with discretion I do have, is I emphasize on marijuana grows those that have any component of violence or any component of having firearms in the grows. And also have an emphasis on the environmental crimes that are being committed by marijuana growers. Those are probably the two I stress the most, that we have to go out and we have to not only prosecute the most, but try to get those laws enforced. I have attempted through the board to set up a program where we will have an environmental officer and an investigator and an environmental attorney who will do nothing but enforce environmental laws, mostly related to marijuana grows. Unfortunately, the money is not there, so we have to do what we have. I can't let homicides go unprosecuted because we're prosecuting marijuana grows. So it's a balance, and we have to do the best we can.
Thank you. Andre, 1 minute of follow-up or rebuttal.
Very good. The United States Department of Justice has issued guidelines to federal prosecutors regarding prosecutions of marijuana crimes in those states where medical marijuana is legally recognized. And I think it's a good starting point for a county DA to determine what cases deserve attention and what cases don't deserve attention. The primary leading candidates for enhanced enforcement are marijuana grows involving violence or the use of firearms, as Don correctly cited, destruction of natural habitats and pollution, that's the number 2 on the Fed's list. The other items on the Fed's list are preventing the distribution of marijuana to minors, preventing interstate trafficking, preventing marijuana activity from being used as a cover or pretext for trafficking, preventing the growth of marijuana on public lands, preventing trespass grows, and if I could add a special Lake County element to this list of prohibited conduct, I would say clearly my office will prosecute home invasion robberies even when the person whose house has been invaded is a medical marijuana user.
Thank you. Don, 1 minute of follow-up or rebuttal.
A lot of what he said is what we've been doing for the last 3.5 years that I've been there. But you have to also realize, I know there are federal laws prohibiting all marijuana use for the most part, but we don't take our marching orders from the United States Department of Justice. If anything, we take our marching orders closely to the Attorney General of the state of California. They'll set the guidelines. They cannot tell us what to prosecute, what not to prosecute. They cannot control us. But if we don't do our job, they'll be on us, and they will be doing the prosecution themselves. So, you know, there's a big rift and big difference between state prosecution and federal prosecution. What the feds do, the feds do. That really doesn't have a lot of concern over my office and how we prosecute cases.
Thank you. Question number 5 would be, Lake County has a large veterans population. Lake County has a large veterans population. It has been suggested that a veterans-specific court should be implemented locally in order to address the unique needs of veterans, especially those returning home from active duty who have suffered brain injuries and have resulting behavioral issues. Do you agree or disagree with a proposal to set up a veterans court, and do you believe it's feasible? 2 minutes.
Yeah. Yes, I do agree with it, and I have been working with the Veterans Administration. I believe Jones did it with mostly a guy named Larry Meck, who's heavy into the Veterans Administration. And the Veterans Court, I think, is now being held in Yountville, and we've cooperated as much as possible. It's a new program getting underway, and we have been sending some people down to Veterans Court. And incidentally, I definitely support the veterans and their efforts. I've talked a little bit about my Alternative to Community Service program, and in that program, the DA's office has contributed, and I'm going to have to guess here, approximately $7,000 to $8,000 just for veterans, for Veterans Court, and different type of mental issues that veterans are facing.
Thank you. Andre?
I'm not aware of any criticisms that have been directed at our Superior Court and how it's handled cases, regardless of whether or not a defendant is a veteran or not. I don't know who's made this proposal. I certainly wouldn't view a Veterans Court as a substitute for the court system we already have. I would not oppose programs designed at helping veterans avoid offending. Call it a court, call it intervention, call it diversion. There's many different labels. I'd be in complete support of a program that's going to help vets who are having a hard time adjusting to coming back after serving their country. We certainly don't need to be putting those people in Hill Road on nonviolent offenses. I support the spirit of that program. I don't think there's a need for a separate court for that type of program.
Thank you. Don, 1 minute of follow-up or rebuttal.
Yes, first, the Superior Courts here do not have the equipment, the time, or the resources to deal with what a Veterans Court will do. They've worked throughout the state, worked very well throughout the country. And the idea of the Superior Court really is to punish people, to rehabilitate them, and to, in essence, put them in jail or certain programs. The Veterans Court's philosophy is different. They want to help the vet. They realize that a lot of vets are suffering from post-traumatic stress syndrome. They're suffering from a lot of issues. The veterans know how to deal with their own, much more so than what a Superior Court has the ability to do.
Thank you. Andre, 1 minute of follow-up or rebuttal.
Not necessary. I'll cede my minute.
Okay. So we'll start with you then. Next question. Audience member would like to know, how will each candidate ensure that every citizen is treated fairly and without favoritism or bias within the district attorney's office?
Within the district attorney's office, we are going to, first and foremost, if I am elected, do a top-to-bottom evaluation of practices and procedures that have been concealed or murky for the past 4 years because the current district attorney has ceased to issue formal press releases. We're going to look at, we're going to do an internal audit of how the district attorney's investigators have been spending their time for the last 4 years. And we're going to look very carefully at whether a significant portion of that time and energy has been devoted to politically motivated cases. We're going to report to the voters what we have found. And then we are going to tell the voters what our priorities as a department are going to be with respect to how we allocate our investigators' time and energy and effort. District attorney cannot police the legitimate behavior of other local law enforcement agencies here in the county, such as Lakeport PD, Clear Lake PD, but we will certainly investigate vigorously any alleged credible allegations of police misconduct or police criminal activity. I think that's a good, solid 2 or 3 steps in the right direction to ensure that the perception that the Lake County District Attorney's Office is politically biased in its activity will be dispelled.
Thank you. Don?
Just briefly, how we're going to ensure that people are treated equally without favoritism is being done. It's always being done. It's been done even before my administration came in. I know of no case where it's been, people have been treated unequally or a favoritism to one or another. We don't do that. If I may speak quickly to the press releases, I didn't know what to say about that. I mean, after this is over, maybe if people want to talk to Elizabeth Larson or somebody from the Record B, press releases are given regularly. The press has my cell phone, my inside line. They're welcome to call me at any time, day or night, and they do. And with press releases, I give as much information out to the press as we can. I cannot compromise investigations. I cannot release confidential information. But beyond that, I think we have a great working relationship between the press and myself. And also, your comment, you can do an audit, and you can find out how the attorneys spend their time. I can tell you right now how they spend the time. They work their backsides off prosecuting crimes. And I'm very proud of each and every one of them, the time and effort that they put in to do their job. They're very dedicated people. So anytime you want to do an audit, you come on to my office right now, and I'll show you through the audit. You can do whatever you want. And then I think you should apologize to the attorneys because of the job they are doing. Thank you.
Andre, 1 minute of follow-up or rebuttal.
Point and clarification, I think Don misunderstood what I said, or I might have misspoken. The black box in the Lake County District Attorney's Office is not the field work being done by our deputy district attorneys. It's the work being done by District Attorney Anderson's DA investigators, who operate behind a curtain that does not tell the voters of Lake County who they're investigating, how they're doing it, and what tools they have to their disposal to do that. That's where some thorough house cleaning needs to be done. I know of one very popular, a very well-known politically motivated case in this county, and I know of one case, the Lazard case, where you gave a sweetheart deal to a sex offender, Don, and we'll be talking about that later on.
I would welcome.
Andre, are you finished?
No, I'm done.
Okay. 1 minute of follow-up.
I'd very much like to talk to the Lazard case, because obviously you have not read the Lazard file. Had you read the Lazard file, if you had read the court transcripts, you would know that the judge agreed with my decision. I stick by my decision, and hopefully this issue will come up in a few minutes. As far as our investigators, we have the best investigators in this county working for our office. And no, we don't go around always telling people we're investigating them. That would be ridiculous. Not everybody knows our resources as well, and they never will know the resources that we have. Things we do not divulge. And anybody who's been involved in the criminal justice system knows there's a lot of secrecy that goes on. Because if you don't have that secrecy, you don't make your cases.
Thank you. Question 7, and we'll begin with Dawn. The district attorney's office doesn't just prosecute defendants for crimes, it also offers support services for victims of those crimes. Discuss what you think are the unique needs of crime victims in Lake County and how, as district attorney in the next 4 years, you would advocate to improve conditions for victims.
We have a victim witness division made up of 6 people. Well, actually 5.5 because one is part-time. I don't want to use the word that they comfort them, but they see them through some very hard times. Probably the hardest times that they have is you have children who have been sexually molested or beaten by relatives or strangers. You know, I've watched these women in work. They are tremendous about getting information out of these victims, and at the same time comforting them, making them feel as best they can under the situations that they do. We'll continue to do that work, and I very much applaud people in victim witness. What I have done in victim witness is I have sent 3 of our victim witness advocates to a specialized school to do what we call MDIC training, and that is the interview of these children in a secure environment, the tape recorder that we use for court. And they are starting to do a lot more of these interviews than law enforcement to free up our resources and probably put a little bit more of a, how would you say, motherly touch when we're dealing with some of these victims than some of the police officers were able to do. Other than the investigator, my female investigator who's in the audience, and I won't say anything bad about her. She's been very good about it.
Are you finished? Did you want to take the rest of your time? Still 30 seconds. Dawn.
No, go ahead.
Okay. Andre?
In my 7 years in Lake County, I've never heard a critical word uttered by a single person about victim witness in this county. I have no reason to think there are any problems there. The suggestion I would make is perhaps we can find some more money so that the good work that's being done can be increased and extended to other areas of the county. I can't criticize something that I think is operating well. I can say I think I've got a good shot at writing better grant applications than Mr. Anderson because I've written a lot of them in my career. I think unwavering support for victims of crime is an essential job of the district attorney. To the extent that the district attorney can engage in programs that will help potential victims make better life choices and avoid becoming victimized in the future, that's something that we would want to bolster as well.
Thank you. Dawn, 1 minute of follow-up.
I'll be very brief. Our victim witness goes to every area in the county. We're not targeting Lake Forest or Clear Lake or any place. Any place in the county if the crime occurs, where there's a victim, we will go there. As far as grant writing, I'm glad my administrative coordinator Doris is not here to hear that. She does most of our grant writing, and she's extremely good at it. And if you could do better, that's wonderful, but I don't think anybody in this county can do better than Doris. Even the professional grant writers that the county has hired to assist in grant writing, they don't top her. Thank you.
Thank you. Andre?
Doris probably isn't somebody I'd want to take on, but Don, I know I can do a better job writing a grant than you.
Okay, question number 8, and we'll start with Andre. This is a two-parter. One of these parts may not be completely applicable to you, but go ahead and feel free to address this how you wish. What cases should be plea bargained? And how do plea bargains or dismissals figure into the convictions rate?
I think every case where there's evidentiary uncertainty or a risk of an unsatisfactory outcome at trial should be plea bargained. To the extent that plea bargaining can affect the numbers that one touts as being results, I think a softer position with respect to negotiated dispositions is going to push your success rate up. I think that's been done in the last 4 years. I don't think the district attorney's office under Don Anderson's tenure is prosecuting as vigorously as Don's predecessor did. And I think Don's been very open about his flexibility in negotiating and encouraging his deputies to negotiate plea bargains as well.
Thank you. Don?
Yeah. The first question is, what cases should be at least plea bargained or attempted to? It's almost every single one of them. We have roughly 5,000 to 6,000 cases come through our office every year. Last year there was a 27% increase in the felonies prosecutions without the increase of a single deputy DA, without the increase of a single judge to hear these cases. If there was no plea bargain, people would be walking from crimes all the time. The court system could not keep up with it. We would need 20 or 30 judges to hear the cases if there was no plea bargains. It's kind of been insinuated I'm an easy mark for plea bargains. Well, I don't think you can go to a defense attorney in town and they'll call me easy. But I do want to be fair, and I will be fair. We have a tendency to charge a lot of crimes in a single complaint, but we try to make every resolution as fair as possible. That's fine.
Andre, 1 minute of follow-up or rebuttal?
I think my lack of success in finding a defense attorney in Lake County who is willing to run for this office is based at least partly on the fact that defense lawyers in Lake County are getting good results for their clients without having to work as hard as they may have had to under another different district attorney. If you're getting good results for your clients and you're not spending time burning the midnight oil for trials, that's good for the defense bar, and I applaud them for that. The problem with softening your stance and being flexible is that you might get less a resolution that's not in the best interests of justice and in the best interests of preventing future criminal activity by a particular offender. But it's a flexible situation, and taking a hard position isn't always the best, but neither is taking a soft position.
Issues. You asked the defense attorneys, why don't they run for office? And I don't know what Ross has meant by his answer, but I asked them if maybe, just maybe, it's because we're functioning well and we're doing a good job, and they know we're doing a good job, and that things don't need to be changed, just a wholesale outright change just to get elected. Secondly, the plea bargains is one reason, one criteria you really need to make a plea bargain is the experience to know the difference between a good deal and a bad deal. And hopefully, if you get elected, you will listen to the people at the office, because unfortunately you don't have the experience yet to do that.
Thank you. Start with Dawn. How will each candidate enforce the rules surrounding the records information management system within the district attorney's office?
Our position right now is that we don't have access to RIMS. So there's nothing to deal with how we do RIMS. I could go into the history of RIMS and why we were turned off of RIMS, and maybe I'll approach it that way. But shortly after we took office, it was accused that our officers or investigators were made some around 3,000 entries into the RIMS system, and it's a misuse of RIMS. However, those 3,000, almost every single one of them was updating the information in RIMS, and the system was working well. Our investigators would go in there. If we have a new address, we would add that address of the person into RIMS. So now you have the old address and the new address. When we're cut off of RIMS, we don't do that anymore. When our investigators need information or report, they could access that information. And we did. It was a great tool. But unfortunately, that was taken away from us. And there's a lot of theories why it was taken away. You can do timelines, whatever you can do. But I will tell you this. An issue came up with RIMS where the sheriff said that he is going to, not asking, but is going to start sending paper reports over through RIMS. Without even talking about it, that's what he did. And I said, no, we're not going to just willy-nilly do this. I'm not opposed to the idea, but we're going to have a process to do it. And we were going to have a meeting that day. I could not attend that meeting, but I had an emergency come up. That afternoon, we were cut off of RIMS. So everything went downhill from that. If there is a new sheriff next year, I anticipate not only our office be given access to RIMS, but also we can get a county-wide RIMS system going where Clear Lake Police, Lakeport Police, probation, the DA's office, they're all going to have one system we can all rely on to do a better job. Thank you.
Thank you. Andre?
I'm rather familiar with the RIMS controversy, and in my opinion, I think the problems that have plagued the relationship between various law enforcement agencies have much more to do with personalities and political agendas than it does with technology or failure to update password lists and moderate the number of users on a particular technical tool. I would very much like to see the RIMS controversy laid to rest for the rest of the time, and I think the likelihood is much greater after the upcoming election that will happen than it has been for the last 4 years. I believe, based upon what I've watched in recent years, excluding the already inflamed opinions of many people, that both Sheriff Frank Rivero and District Attorney Don Anderson have a shared responsibility for the organizational breakdown between their agencies. That shared responsibility isn't equal. In truth, it has been fairly one-sided. But they are both equally responsible for healing and correcting that breach, and that hasn't happened yet. The good news is there's an election coming up, and I'm the only candidate for DA who can say without equivocation that I'm ready to work with the people's choice for the Lake County Sheriff, regardless of whether it's Mr. Rivero, Mr. Chalk, or Mr. Martin. That's a pledge Mr. Anderson can't make.
Thank you. Dawn, 1 minute of rebuttal or follow-up.
Let there be no mistake. And I'm not going to sugarcoat anything. I never have and I never will. Sheriff Rivero and I do not get along personally on about anything. However, with the Sheriff's Department, our office gets along extremely well. We welcome the Sheriff's deputies and administration into our office at any time. And we have a great working relationship. Unfortunately, the Sheriff Rivero and I cannot communicate with each other. And I'm not going to go into blaming him or blaming me or anything like that. It doesn't really matter because hopefully, one way or another, this thing is going to come to an end in a few months. At any time you want to talk to me about the problems we've had, I'm open to talk to you about it and tell you the whole truth. Unfortunately, we don't have that time right now to do that.
Andre, 1 minute of follow-up or rebuttal.
I think there's an issue that Mr. Anderson or myself could improve with the way the district attorney's office deals with confidential information and a separate category, confidences that aren't statutorily deemed confidential information. The law requires that certain rules be observed to keep private privileged information confidential. I think also there's a perception that the Lake County District's Attorney's Office has an open door policy not only to law enforcement but to various members of local press, and that revolving door results in a lot of information leaving the District Attorney's Office in an inappropriate manner. I've said that's a perception that I've heard. There will not be an open door for confidential information in my administration.
Thank you. Next question, we'll start with Andre. What is the one thing you would most like to improve in the local legal system, and how would you act in your capacity as district attorney to accomplish that change?
The biggest problem in our criminal justice system right now is for the past 4 years there has been an internal war between agencies which under ordinary, normal, rational circumstances should be working hand in glove. In my work as an attorney, I've helped people bridge incredible gaps, solve very serious problems, and come to a position of being able to work together for the benefit of all. Lake County has a finite pile of resources to devote to dealing with criminal justice problems. The notion that a district attorney and a sheriff's office can entertain an internal war for a number of years is anathema to the notion of a well-administered criminal justice system. We're going to end that war with this upcoming election, and the Sheriff's Department, all the other police departments, CHIPS, and the District Attorney's Office are going to work hand in gloves for the protection and safety of the voters who pay all of our paychecks.
Thank you. Don?
Yeah, I'm sorry, I did not hear the whole question.
Okay. What is the one thing you would most like to improve in the local legal system, and how would you act in your capacity as district attorney to accomplish that change?
Now, I do agree one of the things that really needs to be done is interagency communications and cooperation between the different agencies. But also, you should also think it's not just, as you call it, a war. I don't call it a war, not by any means, because all the officers, all the troops, all the soldiers all get along. It's just maybe the department heads all don't get along. And the war is not just between me and the sheriff. Sure, there's, as you put it, this war, we have our disagreements. Also, there are disagreements with the chief of police of Lakeport and the chief of police of Clear Lake and the board of supervisors who did a no confidence vote. And down a long line of people have had difficulties with the one department head, not just myself. And so you're painting a picture of maybe a political picture that, okay, it's me versus the sheriff. Okay, maybe you just sit back and look at it. It's not just me versus the sheriff, it's the sheriff versus this department, this department, this department, all down the line. And maybe, maybe I'm not the greatest administrator and I've got a hard head and I'm not going to take any stuff from a department head just because he is a department head or a sheriff. There are things that I have done that I'm constitutionally obligated to do, like putting him on a Brady list. I had to do it, or I'm negligent in my duties. And I will not do that. I will not create a two-tier justice system just because one person is a department head or a police officer or a board of supervisors. They're all going to be treated equally and under the same series of laws. And, oh, sorry. No. Thought you were waving that at me.
No.
That's fine.
Andre, 1 minute of rebuttal or follow-up.
Neither Don Anderson nor I can control or answer for the Board of Supervisors' activities. Likewise, we're not in control of Lakeport PD or any other number of other agencies who have been involved in various squabbles and struggles in the county. I ran for district attorney in order to try to bridge that gap and heal a detrimental breach in our criminal justice system. I don't accept the truthfulness of Don's statements when he says it's not just me. I think Don has made amply clear his political motivations. I don't agree with his procedures, and I don't think the office of District Attorney did as good a job as it could in correcting these problems. I don't have all of the information about Mr. Anderson's Brady determination. Nobody out here does, other than the people who work for Mr. Anderson. What I can tell you about a Brady determination is this. That was painful. I'll get in my closing.
Don, 1 minute of follow-up.
First, the DA does have a lot of influence in making things work. I have a tremendous relationship with Phil Lake and Lakeport Police and probably every other law enforcement agency here. Now I have coffee with them, I will have breakfast with them, we'll talk, we're free, I'll help them and they'll help us at any time. The Brady determination, it's going to Lake County News site, it is on the website. My entire report is on the website and welcome anybody to read it. And your last comment about political motivations, I don't know what the heck you're talking about. I am politically motivated to put the sheriff on a Brady list and have to go through all this for the last 2.5 years. I'm motivated. That makes me a masochist or something. I didn't want to do it. I don't want to do it. But by God, I will do it when it's necessary.
Thank you. The last two questions are going to be the two of you questions. So the first one, we're going to start with Don. Don, you will be asking Andre a question. Andre, you'll have up to 4 minutes to answer. Don will then get a follow-up or a clarification question if he wishes. And then Andre, you'll have a minute to answer. Same process afterwards, same timing when you go to ask your question. So Don, go ahead.
In a previous interview on the radio, you admitted you have really relatively almost no criminal law experience. And you also said that you would not be involved in the management or in the cases, or the felony or misdemeanor cases. And the decisions made by a DA's office, or my activities, or any DA, is probably 90% criminal law related, and maybe only 10% administrative and nothing to do with law. If that is true, if you're elected district attorney, what do you envision your duties will be, and what will you do for this county if it's not criminal law?
I don't think I've stated that I wouldn't practice criminal law. I think I accurately stated that my practice time as a brand new attorney was limited to a couple of areas of law, and that I did not have a full-time criminal practice. I recall the question Mr. Anderson is referring to, but my recollection of my response was, are you going to be doing day-to-day line work in court? Maybe I misapprehended the question. I'm sure Mr. Borg will be the first person to tell you what he thinks he asked me on that particular radio program. The district attorney's name goes on every criminal pleading that the office handles. The district attorney is responsible for the handling of that case. Mr. Anderson has touted many times, I've managed thousands of cases. If I'm elected district attorney, I'm going to be able to say that as well after 3 years. What I bring to the table is intellectual horsepower, integrity, a commitment to upholding the law, unbiased handling of cases, and a host of other characteristics and qualifications that I am confident prepare me well to be a capable, competent district attorney in a very quick amount of time. I'm not running to be a line prosecutor, but I may well spend some time working as a line prosecutor. That's not going to be during the first 3 months of my administration. I'm going to be working on cleaning up the problems that I sense exist there on day one. there's good news for the voters. If I do get elected district attorney, I've got 5 months to prepare and to work with Mr. Anderson on a transition. That's plenty of time to get up to speed on legal matters that I was working on 20 years ago. I know that the first and probably most substantial criticism one can launch at me is he doesn't have any experience, but I have to tell you, being a long-term law enforcement officer doesn't necessarily mean you're going to turn out to be an exceptional prosecutor. We don't have line prosecutors in Lake County who are courageous enough to challenge Mr. Anderson. If you look to Sonoma County, you see a very brave young lady challenging Jill Ravitch. If you look to Humboldt County, you see 4 candidates challenging each other for the seat of the district attorney there who's retired. It's not unusual in the big city, so to speak, for junior prosecutors to challenge their boss when they perceive that the office is not being managed in an appropriate way. That, unfortunately, does not exist in Lake County. And you can ask Mr. Hinchcliffe or Mr. Bohr why neither of them are sitting up here in front of you today. My guess is they'll tell you, he's doing a great job. He's leaving us alone and letting us do what we want to do. It's not going to be that way if I get elected district attorney. I have a lot to learn, and I've got a lot of energy and a lot of commitment to learn it. I'm done.
Don, you can have a follow-up question or clarification. Do you want to do a follow-up question for him based on anything he said?
No. No, nothing worthwhile.
Okay. So Andre, it now goes to you. You can ask him a question. Don, you get up to 4 minutes to answer. Andre can then follow up with a question, and you get another minute to finish up.
Mr. Anderson, on September 30th, 2010, you sat here in the Board of Supervisors chambers for another district attorney candidates event, very similar to tonight's event, which was also coincidentally moderated by Ms. Larson. At that event, you made the following statement to the voters of Lake County regarding your suspension on September 1st, 2010 for failure to maintain your MCLE requirements with the California State Bar. I'm going to read to you, Mr. Anderson, an excerpt from a transcript that's been made from the September 30th, 2010 candidates debate with Mr. Rhodes. At that debate, you stated in your closing statement as follows. So, there was really no time period that I was ineligible to practice law. And as soon as I learned of the deficiency in my continuing education, it was taken care of. But that administration action is on my website. So that is my disclosure. Why I was audited, I don't know, but that's politics. Mr. Anderson, were you truthful when you stated to Ms. Larson that there really was no time period that you were not eligible to practice law in September of 2010? And if you're not, why were you not truthful at that time?
First of all, I was truthful at that time, as I'm truthful now. And if you want to bring up something that happened 4 years ago, let's do it. What had happened, I'll just say it just like it happened now, like it happened before. I did not turn in a little card we have to turn in every 3 years that I completed all my MCLE credits. I was negligent in it, no question about it. And the bar had sent me a letter, and I was in the middle of the campaign, didn't respond to it. So I was made automatically ineligible to practice law. Now, I can't say the exact dates, but I wasn't prepared for this. But I was automatically made ineligible, but did not receive any notification I was ineligible. When I sent my card in to do it, which was, I think, about 5-6 days later, I got a call from the bar, and it says, no, you're already ineligible. From that point in time, I did not practice law. And I went and took, I had plenty of units, but I think it was in ethics, I was deficient by 2 units. So I went online, took the class, did it, reported it to the bar, and then that same day or the next day I was reinstated. And coincidentally, about a week later, I received notice from the bar that I had been reinstated. The next day, I received a letter from the bar that says, actually, I was ineligible. So it was like it was reversed. They reinstated me the day before they gave me notice that I was ineligible. And during that time period, I think it was about a 5-day time period, I had made some court appearances in Lake Fork and in Clear Lake, not knowing I was ineligible at that time. That's what it is, and whatever you want to make of it.
You have 1 minute or one follow-up question?
Okay. Mr. Anderson, on October 2nd, 2010, you did a radio show with KPFZ radio host Herb Gura regarding, among other things, your book and other interesting stories about your campaign. Were you truthful on October 2nd, 2010, when a deputy district attorney by the name of Susan Cronus called into KPFZ and asked you whether or not you practiced law during the time of your suspension? And I'll read to you what the transcript of that radio show says. As soon as I learned about it, there was a 1-day period. I was lucky I didn't have any court that day. If I did, I would have had to have somebody cover for me, but I had no court that day. The next day I was reinstated and everything was fine. Was that a truthful statement, Mr. Anderson?
That was absolutely truthful, I just explained it. I mean, I can't say any more. As soon as I learned of the inactive, like I said a minute ago, I took the test, and that day I didn't have any cases like I said on the radio station. And it was corrected, then I can...
Do you know today how many days you were suspended?
It was approximately, and I have to look it up if you really want it, it's about 7 days total. And first of all, you got to remember, you can't mislead. If you're going to be a DA, you got to tell the truth. It was not a suspension. There's a big difference between suspension and being inactive. So if you're going to say it right.
Okay.
Okay.
Do you know how many times you appeared in court while your license was on inactive status?
Looking back, I think it was 3 days. I was doing a trial in Clear Lake for 2 days and a law in motion for 1 day. That's my recollection. Of course, now we're talking almost 4 years ago, too, so I could be off by a day, I could be off by a day. I don't know what to tell you.
So your statement today was that you think you made court appearances for 3 days while you're inactive, correct?
About 3 days, yes.
Are you
The
aware?
court appearances that I made were all when I did not know I was inactive. As soon as I determined I was inactive, then no court appearances were made.
Okay, thank you. We're now going to move to closing statements. Anything that you want to discuss? Was a question earlier that you didn't get to fully answer. Just to sum up, comparison of yourself with your opponent, it's up to you. The closings, again, are 2 minutes, and we'll begin with Dawn.
Just very briefly, Andre Ross has made some statements which it's kind of offensive, not only to me, but I think to everybody working in the DA's office and in the court system. He says that the system is broken. It's dysfunctional. The criminal justice system is dysfunctional. That is not the case at all. We have the best criminal justice system, not only in this state, but in this country and on this planet. You go to other criminal justice systems in other countries, it is nothing like we have in our system. I'm very proud to be part of our criminal justice system and working well within it. If you say that and I don't know what you're trying to mean, that why Ed Borg or Rich Hinchcliffe or Rosa Carter have not run for my office. That's something you're going to have to ask them. It could be maybe they're scared to death of me that I'm going to do all kinds of nasty, mean things to them, or maybe they're happy with what they're doing. And maybe things are working and they want to keep it working the way it is. You mentioned there was some housekeeping you want to do, some political motivations, confidential information being leaked out. And the one comment I really made note of, you have a sense there's a problem in the office. If you're going to make those allegations, tell me what it is. Because if you know something I don't know, I would love to be able to address it. But you're not coming out with any information other than some vague generalities out there of what you sense. Okay. But getting back to this, to my tenure in the DA's office, all I can say, it has worked. Our conviction rate has improved quite a bit. We've done programs that seem to be working. The confidence I think the DA's office has, or the public has with the DA's office, has improved tremendously. I want to keep it improving. Hopefully the voters don't try to fix something that's not broken, something that is working well. And the only thing I really take offense, not to me, what you said about my people. And that's offensive. Thank you.
Thank you. Andre.
I think many voters in Lake County have been very vocal and open about their dissatisfaction with the Lake County District Attorney's Office. And Don, as popular as you might be with your deputies and your staff, you're not that popular with the voters of Lake County. I've got a much grander agenda than Mr. Anderson. I want to see public safety emphasized as our #1 priority. I want to see public integrity, including that of the District Attorney's Office itself, a top priority. And I want to see equal justice for all. Whether you're left on the political spectrum, right on the political spectrum, down at the bottom, or way at the top. Equal justice for all, that's my third priority. When a prosecutor's desire to win trumps his or her willingness to speak the truth and act accordingly, we are all truly in a serious, problematic situation. In September of 2010, Mr. Anderson was in a heated political battle for the district attorney's position. Mr. Anderson disclosed to the voters at a debate that there was a problem with his licensure. He didn't give a full disclosure then, and he didn't give a full disclosure several weeks later when queried by Suzanne Cronus, and he gave a different disclosure today. This kind of sounds like a Brady situation to me, because Mr. Anderson's explanation about how he concealed or misled or obfuscated about his lack of licensure for a week in September of 2010, in my opinion, undermines Mr. Anderson's credibility to a great extent. Mr. Anderson, at that debate in 2010, you said if you failed to do what you wanted to do, you would not run again. I ask you today to consider that offer again and to step down from the office of District Attorney.
Okay, that brings a close to this evening's forum. I want to thank both of you very much, Andre Ross, the challenger, and Don Anderson, the incumbent, for taking part. And thank you for watching.